Hi, good afternoon. My name is Shani Underwood, and I'm the COO of Ringo VMS Solutions. Ringo offers staffing firms the ability to roll out contingent labor management software to your clients without having to invest tens of thousands of dollars. All of us here at Ringo are honored today to be today's webinar sponsor for changes to the law and insurance requirements affecting the healthcare staffing industry and contractual relations. Our panel speakers today include Martin Borosco, as our moderator, staffing practice leader and partner of Becker LLC. Tony DeMicantonio, panelist, VP and staffing practice leader at Odell Stutner, and Christopher Letty, panelist of counsel and staffing group member of Becker LLC. Thank you for your time today and enjoy this webinar. Marty, I'll pass it to you as our moderator.
Thank you, Shani, and appreciate your support for this program. I apologize, everyone. I'm having technical difficulties on my end, so I'm unable to get my camera to function. So I will spare you from having to see me during this webinar. But, we've got a really timely presentation today, a combination of factors really impacting the healthcare staffing industry. Obviously, we're coming out of a pandemic. Even more important, we have a new administration. There's a number of other influences that are really impacting the industry. And what we want to focus on today is that particular impact. And that is the impact that this is having on certain legal compliance issues and on the insurance market for healthcare staffing companies. So that's where our focus is going to lie today. We've got a great panels here. We've got Tony and Chris who really spend every day with clients in this area, really helping them deal with these questions, which have become quite pressing. I want to start with the first topic, and that's independent contractor classification. I'm going to try and set the table for this discussion a little bit. And that is that really there's a new approach and a much stricter scrutiny being applied to independent contractor relationships. The new administration has indicated that they favor a stricter test. There's states out there, and we're going to talk about that a little bit, that are moving towards a stricter test. And it's leading to a constant question that we're getting from our clients. And that question is, can I have independent contractor relationships anymore? What about with nurses, with allied professionals, with doctors? If I can, what do these relationships need to look like? What are the kind of the do's and don'ts in terms of structuring these relationships? And that's kind of the first area that we're going to tackle. And Chris, let me turn to you, because this is what you're doing every day with our clients. And maybe you can lay the foundation for our discussion by talking about the different tests for determining whether or not somebody's an independent contractor or an employee that exist. And maybe you can talk about the stance of the new administration and, actions such as that states like California have taken and what impact they're having on the test for independent contractors.
Yep. So thank you, Marty. So different states have different standards depending on the type of claim. For example, you have wage claims, unemployment claims, workers' compensation claims, but each test that a state imposes is generally a form of 3 different tests. It's going to be the IRS test, the economic realities test, and the ABC test. All these tests are very similar in that they're looking for things like control. If the services are being performed are outside the normal activity of employees who are in your business or part of your business, and the opportunity for profit or loss of these workers. The difference between the IRS test and the economic realities test versus the ABC test is that the IRS test and economic realities test are factor-based, right? So they're looking at the factors in totality. It's not just one set factor that's determinative. Whereas the ABC test presumptively considers all workers to be employees and permits the workers to be classified as independent contractors only if the hiring business demonstrates that the worker in question satisfies each of the three conditions, which is A, that the worker is free from control and direction, that the worker performs work that is outside the usual course of the hiring entity's business, and the worker is customarily engaged in an independently established trade, occupation, or business of the same nature that is involved in the work performed. So while on the surface, the ABC test appears to be very similar to the other two tests, it's a much greater hurdle, especially considering it puts the burden on the employer to prove an independent contractor relationship. Further, unlike the previous tests that we discussed, it's not a factor-based test. Rather, each of those three prongs that I just mentioned must be met, meaning if you fail even one part or one prong of the ABC test and you pass the other two, it doesn't matter. You automatically fail the test and the worker is going to be reclassified as an employee. The ABC test is something that you definitely want to become familiar with. It's gained a lot of traction in states. I think most notably was AB5, which is a kind of a ABC test on steroids, because it's definitely part of the Biden administration's agenda to enact it at the federal level. And if it's enacted at the federal level, that means it's going to flow down to the states as well. So it's going to replace the economic realities test, the IRS test, and then because it's more stringent, it's going to take over the state's test as well. Did we lose Marty?
Hey, Chris, thank you. That's really helpful for laying the foundation for us and the rest of our discussion. Tony, maybe I can turn to you for a second. How has the political climate around independent contractor classification impacted the insurance market, if at all?
Sure, thanks, Marty. And really at its core, I think it's done the same thing that it's done to my healthcare staffing clients. It's created uncertainty, right? Our clients are looking at it and trying to understand what impact those tests that Chris just had and just ran us through, and the legislation changes that he just ran us through, what impact are all of those things going to have on their business model? Do they change their business model in fear of those things becoming the new reality? Do they hang back and wait and see what the industry does? You know, there's all sorts of uncertainty around a business owner's, you know, way that they're operating their company right now based off of that. And the insurance industry is no different. You've got carriers who have tremendous uncertainty that the account that they underwrote, the profile of that account that today maybe had, you know, 75% of their business model being W-2, 25% being 1099, they're not so sure that that's going to remain the same by the time the end of the policy year is up because of some of these changes taking place. So specifically, it's affecting them on the compliance side when it comes to final audit. So we're seeing positions like nurse practitioners, physician assistants, some of those roles that in our industry have historically been 1099s, all of a sudden carriers are trying to pull some of that payroll in at final audit and charge the insured for that exposure. And then what's maybe more scary is for the first time ever, we've had some instances of carriers looking at locums, which have historically been the most classic example of independent contractors, and all of a sudden they're trying to pull locum payroll into final audit. So that's, from the compliance standpoint, what's happening right now with insurance carriers in the marketplace. From a capacity standpoint, all of a sudden you've got carriers who historically would write healthcare staffing accounts, passing on the opportunities to write them because, again, they're not sure if the same profile of the account that they see today will continue based off of the changing landscape that we're talking about here today.
Thanks, Tony. Maybe a follow-up question. I mean, that was a good overview of how it's impacting the market generally, but can you get a little bit more specific and maybe in two areas I can think of, I would want some more information. Is one, is it impacting what typical policies look like? And maybe two, is it impacting the lead time to get your quotes and to secure your insurance?
Sure. So it is affecting what policies business owners have to evaluate putting in place or requiring have in place. So one of the ways that you make an insurance carrier kind of go away and leave you alone from trying to pull 1099 payroll into a final audit is by being able to evidence that independent contractors have their own work comp policy. Well, that's not really practical. That's not realistic in the world we live in. I think all of a sudden we're starting to see some of that in California, where we've got some independent contractors purchasing their own policy based off of what's going on out there. And certainly, anytime you're talking about corp to corp contracting, you might see, the chance that some of these corporations might be purchasing work comp. But by and large, most independent contractors don't purchase workers' compensation, and that's because they don't have to in most states. So what insurance carriers are looking for or could look for as an alternative is something that's very popular in some other industry sectors, such as trucking, for example, is an occupational accident policy. Essentially, they want to make sure that if a contractor is hurt on the job, that there is something out there to extend payment in exchange for that injury, so that all of a sudden them as carrier are not being pulled into the equation. So from that standpoint, a lot more of our clients are evaluating the requirement of having independent contractors purchase occupational accident insurance, at least offering it. And we've been working with some of our clients to put an actual insurance marketplace together that their contractors can go to and purchase things like OCAC, professional liability, as their necessary insurance requirements at this point, but then also add things like a little life insurance policy or a health benefits policy, things that themselves as independent contractors really do find valuable past just what's required to do their job. So from that standpoint, that takes a lot more runway to strategically be able to implement something like that versus your standard, call it 90-day, insurance renewal policy timeline.
Well, that really makes sense, since it's a little bit more of a comprehensive approach to getting the coverages you need. Chris, I want to turn back to you. And this is probably just my short attention span, but you did a great job running through those tests. But let's face it, these tests are designed for lawyers and courts, and not really designed for business people. So let's try and simplify this a little bit more for folks in the audience with some just real examples. And maybe we can just take nurses, for example. Can you run through kind of what the analysis is with respect to whether or not a nurse might meet the stricter independent contractor test that the Biden administration favors? And then also talk about some of the do's and don'ts that people should be aware of out there in terms of structuring their relationships with nurses as independent contractors or as W-2 employees.
Yeah, so thanks, Marty. So I just want to touch on something Tony said first, is the locums, they're a totally different category, right? The travel nurses, the lower licensed individuals, they have a harder time becoming independent contractors. The locums should not have an issue really ever becoming an independent contractor, because they're protected by what's called the corporate practice of medicine doctrine, which we'll get into in a second. But essentially that means that staffing firms cannot employ locums, right? They can employ physicians because of the corporate practice of medicine doctrine. Now, back to the travel clinicians, there are some factors that you want to look at when you're deciding whether to make a travel clinician an independent contractor or W-2. The first one, you're going to look at control, right? That's the first thing we talked about. The control goes into the types of instruction given, right? When and where to work, direction on what tools to use, who purchases the tools, who sets the sequence of work. if a staffing firm, if our clients are determining where the work will be performed and when, it could suggest an employer-employee relationship. However, the sequence is usually determined by the worker or the client, and that could then lead to an IC status, right? So it goes both ways. So you really have to look at the substance over the form in that regard. For trial clinicians, they're not going to have their own tools, right? You're not going to be using imaging machines, things like that. They're just too expensive. They're obviously using the clients. So that would lean towards an employee-employee relationship, something you can't get around, right? Then for trial clinicians too, and really for locums as well, they have to perform the work individually. They can't farm out the work to subs, meaning that it's more indicative of an employee-employee relationship. You're also going to look at the degree of instruction, right? The more detailed the instruction that the staffing firm's given to the worker, the more likely it's going to be an employee-employee relationship. An easy example is something we just discussed is physicians. They're likely, and almost in all accounts, a independent contractor, because the corporate practice of medicine doctrine prohibits corporations from practicing medicine or employing a physician to provide medical services. Essentially, non-physicians cannot control a physician with exceptions per state law. However, the physician could still be deemed to be an employee of the client. So if a physician is working for a client, they could still have that joint, or they could still be an employer there. You wouldn't necessarily be a joint employer, but the client then has the risk that the physician could be an employee of theirs. For the lower licensed individuals such as nurses, PAs, they can't work without a supervising physician or practitioner due to the corporate practice of medicine doctrine and various state laws. So the argument could certainly be made that the physicians are free from control and direction of the staffing firm, but not the client. With that said, the staffing firm is likely setting schedules, pay rates, and other items, as well as requiring compliance with client requirements. So the opposite argument could be made as well. So this could really be a toss-up, and again, it's going to depend on the substance or the form. So when you're setting up your contract, you really need to flush this out with the client on who's controlling what and how much is being controlled. The other things they look at are training. Obviously, staffing firms are not going to provide training to licensed individuals, so that would lean towards an IC status. You also want to look at the investment. Again, we talked about tools. They're not going to be investing in their own tools, so that would, according to the test anyway, lean towards a employee-employee relationship, even though it's totally unpractical or impractical. They also, the next two things are, I think, the two biggest things. You want to look at unreimbursed expenses, right? Typically, employees are reimbursed their expenses, whereas contractors are not. And that's not always the case, but that's typically how it works. There's even state laws out there that require employees to be reimbursed. So if you're reimbursing a worker and you have them classified as a 1099, then it could lean towards an employee-employee relationship. Although it's not definitive, it's just a factor. The next one is really the biggest one for me anyway, or one of the biggest ones, is the opportunity for profit or loss, right? There is no opportunity for profit or loss in the contracts that we see. They're paying an hourly rate, you're paying per diems, because the per diems are part of the lure, part of the attraction for these trial clinicians to take on the job. So they have only an opportunity for profit, right? They're not making any investments. They don't have any expenses that aren't being reimbursed. So there's no opportunity to lose that money. So that's going to be a factor that weighs heavily against an IC status. And really in the healthcare staffing industry, there's no way to get around that, right? I mean, I guess you could structure it as a paid when paid clause, but you can advance them the monies. But for all intents and purposes, we know that they're going to be paid. And then you want to look at the permanency or the relationship. If it's a short time period, which typically these are, it leans towards an IC relationship. Whereas if it's an indefinite period that there's no end date in sight and they're at will, it's going to be an employee-employer relationship. And then a lot of times too, we know that trial nurses are, for the most part, they work the 3 shifts, but then they have downtime, right? So on their downtime, they typically do pick up, or it's not atypical for them to pick up shifts, per diem shifts by another vendor while they're out on assignment. If they're allowed to do this, again, that would suggest an IC relationship because their services are available to the market. The last one really is you're looking at, are the services a key part of the business? Are employees of yours, so do you have W-2s performing the same functions for other clients, and now you're going to go ahead and classify this person as an IC? You have to have a really good reason and a distinction for that to apply. Otherwise, the IRS, Department of Labor, they're going to come in and look at it and say, well, why'd you classify this person as a W-2, this person as an IC, when they're doing the exact same job, right? So you're going to have a really hard time overcoming that. So those are just things to consider when you're negotiating your contracts with the client and with the travel clinician.
That's really helpful, Chris. A couple things I take away from that, working in the trenches with our healthcare staffing clients. That last point is very important. You don't know how many folks have, nurses that are W-2 and nurses doing the exact same thing that are independent contractors, and no rational reason other than, the nurse wanted it that way, or for why there's a distinction in that classification. And I think for the audience to really just boil down what Chris said, look, you got to look at it position by position, but general rule of thumb, higher licensed physicians, locums, probably can be independent contractors. Lower licensed nurses, allied professionals, probably going to be difficult to get over the hurdle of making them independent contractors. You have to peel back the onion and really look at it factor by factor. But rule of thumb, that's a general rule of thumb of what you can take from what Chris just said. Chris, I think an important thing for people to understand, because, we're anticipating, in certain states that are moving towards the AB5 test, and given the Biden administration's stance and push to be stricter on independent contractor determinations, we're predicting kind of that there's going to be some audits, there's going to be some Department of Labor actions, there's going to be some IRS action that's going to be taken down the road. I think it's really important for folks to understand what's at stake here if they don't get these classifications correct. Could you maybe fill folks in on that?
Sure. So obviously, if they're reclassified as an employee, you're going to owe all the back payroll taxes, right? Number one. There's also penalties and fines associated with the misclassification of an independent, or as a misclassification as an employee as an independent contractor. For instance, if the IRS determines that an individual has been misclassified, it may levy penalties against the employer, including but not limited to a $50 fine for each W-2 that the employer failed to file, 1.5% of the wages, 40% of the FICA taxes that were not withheld from the employee, and 100% of the matching FICA taxes that employer should have paid. Obviously, on a small scale, this wouldn't be that much money, but if you're employing hundreds of ICs, you're probably talking millions of dollars here. You also have to consider state penalties too. So it's not just the federal, you also have state. Those also consist of monetary penalties. They could be stop work orders could be issued, or they could suspend or revocate your license, obviously, which have a catastrophic effect on the business itself. And I think the biggest monetary risk issue is the wage and hour issues, right? So if you classified workers as ICs when they should have been employees, they're reclassified then as employees. Were you tracking their time? Were you paying them overtime? If you weren't paying them overtime and they were entitled to overtime, you're on the hook for the overtime wages, plus double or triple damages depending on where you are, the attorney's fees for those plaintiffs, and interest on any unpaid wages. And the real scary thing is that there's class action plaintiff attorneys out there that are looking specifically for these cases, right? That are hitting for tens of millions of dollars because they were misclassified and then it flowed down that there were wage and hour violations. You also have to consider benefits too. Obviously, you should be paying or providing benefits to your employees. For instance, the ACA, if they're reclassified, you didn't provide them medical insurance, there are penalties associated with that. And I think for those of you looking to go to market, a big thing too is as you can see, there's a lot of risk here with ICs that is not inherent with the W-2s. So that's going to increase your risk profile. It could drop your multiple down. You could have longer indemnification periods, larger holdbacks, and longer earnouts. So these are all just something to consider when you're making your decision whether to classify somebody as a W-2 or an IC.
Thank you, Chris. Yeah, that's a good point. I do a lot of work on mergers and acquisitions, and there's no doubt that buyers are going to feel more comfortable acquiring sellers who have taken less risk in their employee classification versus sellers who have taken more risk in their employee classification. There's no doubt about that. Chris, just kind of, I hope this doesn't come at you left field a little bit, but you had brought up the corporate practice of medicine, and I think that's an important issue to touch base on, both from a legal compliance, and Tony, I'm going to get to you with this in a second as well, with respect to the insurance market, because I know it has an impact in both areas. Talk a little bit about the corporate practice of medicine doctrine, because most states have a statute that prohibits the corporate practice of medicine, and explain how it affects how you structure relationships with physicians, locums, and folks of that nature.
Sure. So as you said, all states or most states have their own corporate practices of medicine doctrine. So it arises from those state statutes or regulations, and they're based on a number of public policy concerns, right? Namely, they're to avoid the commercialization of the practice of medicine and to avoid interfering with the physician's independent medical judgment. Most states do prohibit the corporate practice of medicine. However, almost every state has broad exceptions, such as for professional corporations and employment of physicians by certain healthcare entities. So for example, every state allows for the creation of professional corporations. These state statutes specify how professional corporations have to be structured, who can participate as shareholders or owners, and who must serve on the board of directors. Most states restrict the shareholders, owners, or board of directors of a professional corporation to only licensed persons, right? So only to physicians. However, some states do have exceptions to that, right? For example, Colorado statute provides that all shareholders of a medical corporation have to be licensed to practice medicine in the state, except that one or more persons licensed by the board as a physician assistant may be a shareholder so long as the physicians hold a majority ownership in the corporation. Also, I think it's really relevant to our discussion. Many states also provide for an exception to the corporate practice of medicine to allow for the employment of physicians by certain entities. It really varies by state, with some states explicitly permitting hospitals to employ physicians, some states allowing nonprofit hospitals to employ physicians, and some states allowing the unwritten rule or exception that hospitals may employ physicians. However, all these states require the physician to maintain his or her independent medical judgment, thereby to protect the physician's autonomy of clinical decision making. And I think it's really important to note too that staffing firms, we know, cannot be an employer under the corporate practice of medicine doctrine, right? If you violate the corporate practice of medicine doctrine, there are very steep penalties, right? On both sides, both for the physician and for the staffing company. For the physician, they're going to lose their license or have it suspended. And on the staffing side, you're going to have to be disgorged of your profits, right? Because you impermissibly obtain them by sharing in fees that were otherwise entitled to the doctor. So two very big things to keep in mind when you're doing your risk profile, and to make sure that you do not employ physicians.
Tony, I know, because we've had discussions about this, that the corporate practice of medicine doctrine impacts insurance coverage. Can you explain how it does that?
So really, we've used that corporate practice of medicine doctrine as a way for insurance carriers who want to invest and understand in the right way of doing things in the industry. A lot of times the underwriting side of an insurance company needs something to appease the auditing side of the insurance company. So we will arm them with that corporate practice of medicine to basically say, as Chris pointed out there, that literally you cannot have these doctors become employees of staffing companies. Here it is, here's the doctrine that applies in almost every state around the country. In addition to that, like Chris said, there's ramifications for the physicians. There's ramifications for the staffing company too, where if a carrier tries to force workers' compensation onto a group of independent contractors, whether they're locums or any other class, you're effectively putting a giant red mark from the Department of Labor standpoint next to them saying, well, you're giving these folks benefits like workers' compensation, automatically this must be a W-2 employee. And there's a whole lot of ramifications that come out of that, right? When we are forcing employees from 1099 to W-2, and they shouldn't be. So this doctrine really can become something that helps support our position in the industry for carriers who want to care and who want to invest in doing it the right way. Unfortunately, the flip side of that is that not all carriers want to understand this to this degree. It's just easier for them to take a very black and white position of no. If they've got independent contractor as part of their business model, we don't want to insure the W-2 side of things, which is unfortunate. So really what, the one piece of advice that we found at this point that is the ultimate form of protection is that healthcare staffing firms who have W-2 and 1099 entities, the best way from an insurance standpoint to structure them is to have two separate entities, meaning if you've got your 1099 entity as a completely separate FEIN, we never have to put that entity on the work comp policy. That never hits the insurance carrier's radar. Whereas if you've got everything under one FEIN, you're trying to carve out payroll, X amount to W-2, Y amount to 1099, the carrier is going to see that at audit time. They're going to have the ability to drag it in by virtue of it, being carved out behind the scenes. So that's really, it can help for carriers who care. For carriers who don't care, unfortunately, it's not really any more assistance at that point.
And I think you covered it a little bit, but maybe you can talk about how it makes clients' lives a little bit more difficult, because it seems like it would make clients' lives a little bit more difficult.
So yeah, so when when a healthcare staffing company is running a business that's got both 1099 and W-2, obviously IC compliance is their number one priority, right? They want to do everything possible to make sure that the Department of Labor doesn't come around and all of a sudden, because of a lot of the criteria that Chris ran us through, say, whoa, these folks actually aren't 1099, they should be W-2. That employers just at that point open up to all sorts of fines and penalties and back pay. So the last thing that you want to happen is a short-sighted insurance carrier making a decision in a vacuum to move payroll, to say from a payroll standpoint that they've got to include this 1099 payroll in the workers' comp program, because by default you're now putting your employer in a place where you're providing benefits to these folks, which again is a giant check mark next to a W-2 employee as opposed to a 1099. So it could really be jeopardizing the entire business model when a carrier makes a short-sighted decision like that.
Thanks, Tony. Let's jump ahead to another topic that I think is having a lot of impact on the industry as well, and that's per diem expenses. Obviously, it's always been a lingering question within the industry, but it was really brought to the forefront recently with the AMN healthcare case. So, Chris, let me start with you. Maybe the place to start is talking about that particular case, explaining what the situation was there and what the courts found.
Yeah, so just a general overview. Obviously, we know healthcare staffing companies routinely do pay a base pay as well as per diem expenses for food, lodging, as part of the total compensation, right? The per diem expenses are obviously tax-free, which is a benefit to both sides, right? So instead of actually making, if you're paying them $25 or equivalent of $25 an hour tax-free, obviously they're making more like $35 an hour tax-free. So travel clinicians know this, and it's one of the major reasons that they engage in these contracts. In the recent Ninth Circuit decision of, the case name is Clark versus AMN Services LLC, the Ninth Circuit reversed the lower court's decision that was in favor of AMN and stated that the per diem payments there should have been classified as compensation and not tax-free benefits because the payments were compensation for work rather than as reimbursement for expenses by the travel clinicians. The court there relied on, amongst other things, federal regulation, which states that payments are excludable from wages when they do not depend on the hours worked, services rendered, or other criteria that depend on the quality or quantity of work. The two policies that were in question for AMM were, they had a pre-2014 policy, which stated that the per diem payments were prorated based on hours missed. So for each hour a clinician failed to work, AMM would deduct $18 from the weekly per diem benefits. Then they had a post-2014 policy that said generally, if a clinician contracted to work 3 shifts per week and they missed 1 shift, their per diems would be reduced by 1/3. The court did note that reimbursing travel clinicians for 7 days of expenses, even though most only work 3 days, is justifiable because clinicians are scheduled to work away from home for a prolonged period of time and are not expected to travel back and forth between their home base each week. The court found that the employer's policy of taking pro rata deductions from its per diem payments were whether the employee remains away from home incurring those expenses. Instead, the deductions were connected to the amount paid to the hours worked while still away from home, thereby functioning as compensation rather than an expense reimbursement. For example, a worker may have been too ill to work a particular shift, but would still be traveling and incurring expenses, right? Because of this, the court reclassified the per diem payments as wages, subjecting those to taxes and overtime claims, which I think were somewhere around $20 million. On May 7th, AMN did ask the circuit court to hear the case. That was denied, the full circuit to hear the case, that was denied. And on May 13th, they asked the Ninth Circuit to stay its decision so it could appeal to the U.S. Supreme Court, which will likely take a year or so before that's resolved.
Okay, so we don't have full resolution of that case, and obviously the Supreme Court may or may not hear it, and it may or may not reverse the circuit court's decision. So we've got a little bit of uncertainty for a further period of time. But let's take that uncertainty aside. What should clients have learned from this case, and maybe put more succinctly, what are some best practices that you're advising our clients to take in light of the AMN healthcare case?
Yeah, so the AMN case is really, the court's decision there was consistent with the Department of Labor's handbook, which stated that if the amount of the per diem is based upon and varies with the number of hours worked per day or week, they are part of their regular rate. There was an exception that AMN relied upon, stating that if they return to their home base, in the middle part of the day, then they only have to pay 1/2 of that per diem. The trouble here is travel nurses or travel clinicians are never returning to their home base. They may be returning to a hotel, but they're never going home during that week, right? So at present, we're advising companies to revise their policies to pay the per diems regardless of time worked in a particular week, right? So the case very clearly said that you cannot tie hours of work to the per diems. However, we're also advising that the weekly per diem should only be paid for weeks that they're actually working, right? So, or they're scheduled to work. So if they have week 1, they're working, week 2, they're not scheduled to work, send them home. You're not paying for do not pay for their per diems, that weekly per diem, if they're not scheduled to work that week. Also, you do want to note too that the court's decision was very similar to cases that have been held in the 1st, 8th, and 5th circuits. So I don't think this is going away. I have a feeling that this is going to be the law of the land eventually. So just something to keep in mind. And also, finally, if you're giving per diems, which I'm sure you are, because every travel nursing company is, you have to stay in line with GSA or federal standards for the area that the nurse or the practitioner is in, right? So Miami is going to be different than New York, right? They're going to have different rates. Make sure you stay within those, and make sure that the work is at least 50 miles away from where their home base is, because those are 2 big things that a court or Department of Labor is going to look at when they're deciding whether the per diem should be classified as expenses or wages.
Chris, and maybe I don't want to spend too much time on this next one, but I assume the consequences here with respect to if you're not getting your per diem expenses correct are pretty similar to the consequences you discussed with respect to misclassifying independent contractors, right? These are tax and wage and hour consequences.
Exactly. So you're not obviously you're not paying the FICA tax that you should have been paying. You're not paying state taxes that you should be paying, unemployment contributions, and then the big issue for AMN, their biggest liability there is the overtime wages that they didn't pay, because by reclassifying the per diems as regular rates, it probably doubled the base pay rate, which means it probably doubled the overtime rate. So, and they weren't paid that double overtime rate. So now they're going back having to review all their records and calculate what would have been the overtime rate had the per diem expenses been included in the regular rate. So, and this is a perfect example where you're talking tens of millions of dollars.
That's what I thought. All right, Tony, there's one there. How are you going to insure us for it?
So unfortunately, not a lot of good news here, and it's been that way for quite a long time in the insurance industry. This is literally like a house on fire for an insurance company. Nobody wants anything to do with FLSA claims. The rewards that these class action suits are seeking are astronomical. Even when you end up settling out of court, the cost of not only the indemnification part of it, but the defense costs are just too crazy that insurance companies can't even think about providing any kind of coverage. For a while, we would get a $100,000 type sublimit for defense only with FLSA claims. That's largely disappeared. It's probably not a long amount of time before that completely disappears. But $100,000 is a drop in the bucket for these type of claims. In the very few examples that we've seen of staffing firms challenging this all the way up as high as the Supreme Court, even though they might win the case in the end, they lose in the multi-million dollars of defense costs that they've spent at that point. And there's unfortunately very little way to mitigate that. There is wage and hour specific coverage available, but typically you're talking about significant premiums, and more importantly, probably retentions usually start at about 2 million. So you can see what kind of burn layer the insurance carrier is already chalking up to a known loss based off of their starting point of retentions being set at 2 million. The only other way we've strategically seen some clients cover this exposure is by including it in an 831B micro captive. It's actually the perfect reason why these micro captives exist on the insurance side. So you can insure uninsurable type events, or I should say self-fund for uninsurable exposures. The only problem is 831B micro captives have their own IRS tax scrutiny right now. That's a very real topic. So again, all this translates to no real good solution for employers on insuring away this exposure. Our recommendation is absolutely along the lines of what Chris said. You really need to pay attention to best practices, and you really need to quantify the cost of doing business in certain geographical areas, such as California and other areas around the country that are known to just be prevalent with these kinds of lawsuits.
Thanks, Tony. And one more area of bad news, unfortunately, here is that, you know, the pendulum with respect to employers' ability to get employees to waive their right to be involved in class actions has kind of been swinging back and forth over the last, decade or so. And, a few years back, it had swung a little bit in favor of employers, and some courts were upholding the right of employers to get their clients to waive class actions. Well, that pendulum is starting to swing back the other way, or certainly looks like it's gaining momentum to go the other way. So there may be limited utility in that area as well to control some of that risk. Well, we don't have much more time, but there was one more area that I hoped we could cover, and that was contracting. Obviously, all of these items we've discussed impact contracting, and contracting in general needs to move and be updated in terms with where the industry is moving and heading. Let's talk about industry contracting a little bit. Tony, I know, certainly when we're working on clients together, folks with your background have a lot of good input on client and employee contracts. Talk a little bit about what you're looking at with respect to contracts these days when you're looking at them in conjunction with folks like us or independently with your clients.
Sure. So we do try to limit our contract review with our clients to insurance requirements review, as well as some indemnification wording review. That being said, we certainly don't tend to try to get involved in rewriting or writing indemnification wording. We pull in you guys as the attorneys who are far more qualified to do that. And same with, the scope of some of the services that you're agreeing to and some of those best practices that Chris alluded to before. We can point things out, but we really try to make sure that anytime that there's legal involved, that we're bringing the attorneys in to help write to a solution there. Our goal is just to make sure that our clients understand at a very high level, are they compliant at the insurance requirement standpoint? And do they know what kind of indemnification they're looking at? Is, how much liability are they taking on? Is it unfair, or is it mutual? And with that good baseline, it can a lot of times just give the client an understanding of where they're going in the contract negotiations. Is it something that they think they can handle, or is it something that they need to bring legal into early on? I think the one main area of contracts that's super relevant to medical staffing, and it's been this way for a long time and continues to be that, is in regards to cyber insurance. A lot of client contracts that our clients are forced to sign, including MSP contracts, for whatever reason, they don't always include cyber as one of the insurance requirements, but a lot of times we'll bury their cyber requirement as well as their indemnification requirement as it relates to cyber within a privacy clause of the contract. So it just takes the awareness to make sure that you're not just stopping and starting at that insurance requirement section, that we do need to look deeper into the privacy section, because third-party cyber exposure or the allegation that your temp was responsible for a breach of their data is a pretty significant exposure. The good news there is that coverage is becoming more readily available in some of the cyber forms. Bad news is cyber costs are skyrocketing right now with everything going on, but at least you are able to insure that exposure away appropriately right now.
Thanks, Tony. We're going to be wrapping up, folks. So if you have any questions, because we're in our last few questions that I want to ask, at least, please, you can start entering them in, and we'll answer those as well if we have a couple minutes left. Chris, maybe I can turn to you with respect to contracts. You know, check a couple boxes for clients on a high level with respect to some issues they should be thinking about in terms of how their contracts are dealing with certain points.
Yeah. So obviously, every contract should have a compliance with laws provision. Essentially, the client's going to be taking over your staffing firm's responsibilities for supervising and directing those workers, right? So the client should be making representations and warranties to you that all laws will be complied with regard to the workers. So this can include that they're going to be providing meal and rest periods, protecting them from harassment, providing a safe work site, facility training. To dovetail that, you're going to want indemnifications back from them for their acts or omissions, including any of their violations of law or breaches of the contract. You also likely want to make sure that there's a no hire provision in there to protect your workers from them, or at least a conversion schedule. So for example, if somebody works from 0 to 250 hours, maybe there's a fee of 20% of their first year salary. If they work 1,000+ hours, maybe there's no fee. So those should always be in there, and those are pretty much for the most part in every contract that we see. I think a big one is the limitation of liability for many of the reasons that we discussed here today. We typically push for your liability not to exceed the amount you received under the contract or a work order within the past 12 months. And finally, you want to have latitude to adjust any pricing if there's a change in law that affects your margin, right? So if taxes go up, there's new paid sick leaves that come out. You could have language in there stating that your gross margin shall never drop below X percentage, and that should any laws change that would cause such a decrease, the bill rate will increase proportionally to maintain that gross margin. On the personnel side, you want to make sure that you're protecting your client relationships, so you may want to look at restrictive covenants. So there are non-solicitation, non-competition periods. Obviously, this is going to vary state by state, not permitted in California. You also want to make sure that there's reps and warranties that the workers are not part of any exclusion lists that would prevent them from providing services, as well as that they're going to comply with all HIPAA-related, privacy-related laws. And then we did talk about this earlier. As we know, travel nurses do pick up per diem shifts while they're out on assignment. You have to figure out if you're going to allow this, and if you do allow this, if permission must be received for each additional shift that they pick up. So these are just some of the things to think about, some very high-level things. Obviously, it's a lot more nuanced than this, but those are some high-level thoughts.
Thanks, Chris. Okay, we're going to take some questions, and I've got one here. And Tony, this looks like this one is directed to you. So the question is, at the beginning, you talked about needing lead time to go out to market. Can you just, reiterate how long of lead time you're really recommending in Odell Studner, and why again?
Yeah, so if you are talking about introducing a strategy of establishing a marketplace for your independent contractors and starting to offer them access to product that makes them safer, that makes you safer in some regards, then that's probably something that we're talking ideal state. You're going to want to start having discussions 6 months in advance before you'd like to implement something. And if on the other side of the coin, if we're talking about a workers' compensation policy that you want to make sure that you're prepared for not just a renewal date, but the future, that's also a long time decision-making process, right? So all too often, it's boiled down to like a 90-day process because that's how long it takes to secure a product. But as many people know, workers' compensation and the size expense that is to any staffing company, including healthcare staffing, is so significant that nothing should be boiled down to 90 days. You should be having year-round dialogue with your insurance advisor or your consultant so that you're planning for the future, because a lot of programs that you might want to pivot into aren't just something that you're going to want to make a decision in 90 days. You're going to want to make sure it's an ongoing dialogue.
Thanks, Tony. Okay, a second question here. This one's for you, Chris. The question is, obviously there's a lot of different level of nurses. With respect to advanced practice nurses, can they be independent contractors?
They have a better argument than, obviously, the higher your license is, the better the argument is. And it's really, you're gonna look at the state law, because advanced practice nurses can only be supervised by or collaborate with a physician, a licensed physician. But it doesn't state that unless the state law states that they only have to be employed by them, you lose that argument, right? So for the most part, I would err on the side of W-2, unless there's a specific state that you're in, there's a statute that allows for it, and if the statute doesn't allow for it, then there are ways that we can craft a contract, but it's still going to end up being substance over form. But as long as you're applying all of your APNs one way, none of them are W-2s, that'll help. And it's not going to be a definitive answer, but that will help. But if you're crossing them up, and some are W-2s, some are ICs, it's not going to be helpful.
Thanks, Chris. And let's take one more question. Here it is. What is the risk of classification of 1099 expenses for locum working for a staffing company?
So these are going to be your independent contractors, right? These are your physicians. Again, physicians typically are not going to be employees. They can be employees of the client. They should have a.
Sorry, Chris. The focus that they want is if you're reimbursing those folks their expenses.
Yep. So.
Yeah.
They're a different breed, right? So they cannot be your employees. So even if you are reimbursing them their expenses, it's the likelihood of, because of the corporate practice of medicine, likelihood is they can't be your employees anyway. So there's not a lot of risk there. The real risk is on the client side, because they could end up being considered an employee of the client, but never the staffing firm.
Got it. Another question that just came in, does it mitigate the risk exposure to the client if they provide max rates and guardrails to contingent locum workers?
If they provide max rates. Yeah, I mean, I think the question is saying the max rates on their federal standards. Yeah, you definitely want to stay within the federal guidelines. If you're going over it, they're automatically going to be classified as wages. But again, if these are doctors that we're talking about, they have to be independent contractors. So it just goes back to the prior analysis, whereas they can't be your employees anyway.
All right, thank you, Chris. Okay, well, we've gone a few minutes over our allotted time. Why don't we end it here? Obviously, anyone in the audience who still has questions, I don't know if you've attended any of the webinars that Becker or Odell has, but we really like to give to the industry, and we're happy to answer questions that we weren't able to answer within the time frame of this webinar. So please reach out to me, reach out to Tony, reach out to Chris. We're happy to spend a little bit of time off the clock helping folks in this industry, because industry we love and spend every day. And Tony and Chris, really appreciate the insight that you provided. And we hope this was helpful to the audience members, and everyone have a good day. Take care.
Thanks, everyone.
Thank you, everyone.